everybody, Andrew Reed here with the NCA Exam Study Guide for Constitutional Law 2023. In this series, we are just going through the syllabus for the NCA exam, hyperlink by hyperlink. And today we are on part 7 of my series, and this one will cover Ancillary Powers and Paramountcy. So let's go ahead and get started. Follow along on the screen. So the syllabus starts out here with the General Motors case. This has previously been case briefed. But I did grab a couple of notes here in terms of General Motors references to ancillary powers. And in the subsequent case in the syllabus, they also reference General Motors and ancillary powers in there. So a few more notes in the case that is next. Okay, let's take a look at these notes. In General Motors, they referenced a Board of Commerce case where the Privy Council rejected the trade and commerce power without distinguishing between the two branches as the basis for anti-combines legislation, holding that the trade and commerce power had no independent content and could only be invoked as ancillary to other federal powers. This view was rejected 9 years later in another case. The pith and substance doctrine enables a law that is classified as in relation to a matter within the competence of the enacting body to have incidental or ancillary effects on matters outside the competence of the enacting body. Now, this is from the Hogg textbook by General Motors. Classifies it. It is worth noting that incidental effects or ancillary doctrine are two very different things, and that's explained a lot more clearly in the case after this. Okay, next, in numerous cases, courts have considered the nature of the relationship which is required between a provision which encroaches on provincial jurisdiction and a valid statute for the provision to be upheld. So in different contexts, courts have set down slightly different requirements: rational and functional connection, in Zelinsky and multiple access, ancillary, necessarily incidental, and truly necessary in the McKenzie case, intimate connection, integral part, necessarily incidental in Northern Telecom, integral part, Clark versus Canadian Railway, a valid constitutional cast by the context and association in which it is fixed as a complementary provision in Vapor Canada, and truly necessary in R.V. Thomas Fuller Construction in 1958. So this judge in General Motors says, I believe the approach I've outlined is consistent with the results of this jurisprudence, saying that it is tailored. So these cases are best understood as setting out the proper test for the particular context and issue, rather than attempting to articulate a test of general application with reference to all context. Basically, there's a lot of flexibility in these tests. So the tests are not identical. As the seriousness of the encroachment on provincial powers varies, so does the test required to ensure that an appropriate constitutional balance is maintained. So in surveying past jurisprudence, it is to be expected that some examples of patterns between the appropriate test of fit and the head of power under which the federal legislation is valid will be found. Such patterns exist not only because of a possible degree of similarity between the federal legislation which falls under any one head of power, but also for the reason that certain federal heads of power, for example, Section 9210, are narrow and distinct powers which relate to particular works and undertakings and are thus quite susceptible to having provisions tacked on to legislation which is validated under them, while other federal heads of power, for example, trade and commerce, are very broad, less likely, therefore, to give rise to highly intrusive provisions. Makes sense. So here are the steps in the analysis for ancillary powers here, and maybe summarized as follows. First, the court must determine whether the impugned provision can be viewed as intruding on provincial powers, and if so, to what extent. If it does not intrude, then the only possible issue is the validity of the act itself. Second part of the test, the court must establish whether the act or a severable part of it is valid. And so in cases under the second branch of Section 91.2, this will normally involve finding the presence of a regulatory scheme and then ascertaining whether that scheme meets the requirements articulated in Vapor Canada. and in Canadian national transportation. If the scheme is not valid, that is the end of the inquiry. If the scheme of regulation is declared valid, then the court must determine whether the impugned provision is sufficiently integrated with the scheme that it can be upheld by virtue of that relationship. So this requires considering the seriousness of the encroachment on provincial powers in order to decide on the proper standard for such relationship. If the provision passes this integration test, it is intra vires parliament, as in constitutional, as an exercise of the general trade and commerce power. If the provision is not sufficiently integrated into the scheme of regulation, it cannot be sustained under the second branch of 91.2. I note that in certain cases, the judge notes, it may be possible to dispense with some of the aforementioned steps if a clear answer to one of them will be dispositive of the issue. So, very flexible test here for ancillary powers. Okay, this case I feel clears it up as much as possible. It's much more clear and also gives a nice framework for analyzing the constitutionality of quite a lot of legislation. So let's take a look at this. Quebec v. Lacombe, 2010. Okay, background. Judges gets pretty poetic here. He says, seeking to preserve the tranquility of their rustic setting, owners of summer homes spurred their municipal government to outload an aerodrome on the lake. The operators of this aerodrome challenged the validity of the municipal prohibition on the grounds that federal parliament has exclusive jurisdiction to determine the location of aerodromes. So, issue here, whether this bylaw by the municipality relates in pith and substance to the federal jurisdiction over aeronautics, and if it does, whether that bylaw is valid anyways under an ancillary powers doctrine. So let's take a look. The rule here starts with a Morgan-Teller pith and substance analysis, then a heads of power analysis from the reference for the Anti-Inflation Act, then finally an ancillary doctrine analysis from Global Securities Corps in 2000. So that is a nice set of tools right there to analyze these kinds of cases. A couple other rules that are used here. The law accepts the validity of measures that lie outside a legislator's competence, if these measures constitute an integral part of a legislative scheme that comes within provincial jurisdiction. This is from General Motors. In pith and substance, provisions enacted pursuant to the Ancillary Powers Doctrine fall outside the enumerated powers of their enacting body, again from General Motors. So the conclusion in this case, so these amendments brought are not constitutional and the appeal was dismissed. Here's some of the analysis, and there's a little extra analysis in here because I found it useful to see the detail of how they're logically comparing it, because this is an analysis similar to what I believe they may be expecting on the NCA exam. So the analysis. Well, the preamble of bylaw number 260 states that its purpose is to find a balance between the activities of summer home renters and more commercial land uses. The evidence reveals that the real object of the bylaw is not related to zoning. It does not fall under any provincial head of power. Rather, its essence is to regulate the location of water aerodromes in the municipality, a matter within the exclusive federal jurisdiction over aeronautics. So, since this bylaw is in pith and substance about the regulation of aeronautics, it falls outside the provincial jurisdiction. And next, is this bylaw saved by the Ancillary Powers Doctrine? No, it is not, because under that doctrine, a provision which is in pith and substance outside the competence of its enacting body will be saved, where it is an important part of a broader legislative scheme that is within the competence of the enacting body. The degree of integration required increases in proportion to the seriousness of the encroachment. Remember that from General Motors, where the impugned measure encroaches only slightly on the jurisdiction of the other level of government, a rational functional connection is required. As the degree of intrusion grows more serious, the required degree of integration tends towards a test of necessity. So, here's some of that thorough analysis. At the end of the day, what is missing is evidence of any purpose for the bylaw other than the prohibition of certain aeronautical activities. There's no evidence of a gap in the first bylaw that the second bylaw fills. There's no evidence of a feature of bylaw that the second bylaw enhances. There's no evidence of an inconsistency or uncertainty that it removes from the first bylaw. There's no evidence that the second bylaw is an integrated feature of the zoning scheme viewed as a whole. Indeed, it is difficult to say that the second bylaw is even supplemental to the zoning scheme, given its arbitrary focus on banning aeronautics without regard to underlying land use, and in any event, supplementation would not be enough to save it. In sum, there's simply not the kind of connection one finds in the cases where invalid legislation has been resuscitated through the ancillary power doctrine. Notes, and some important notes here. The ancillary powers doctrine is not to be confused with the incidental effects rule. The ancillary powers doctrine applies where a provision is, in pith and substance, outside the competence of its enacting body. The potentially invalid provision will be saved where it is an important part of a broader legislative scheme that is within the competence of the enacting body. So the incidental effects rule, by contrast, applies when a provision in pith and substance lies within the competence of the enacting body, but touches on a subject assigned to the other level of government. It holds that such a provision will not be invalid merely because it has an incidental effect on a legislative competence that falls beyond the jurisdiction of its enacting body. Mere incidental effects will not warrant the invocation of ancillary powers. Only the ancillary powers doctrine concerns legislation that in pith and substance falls outside the jurisdiction of its enacting body. Laws raising a double aspect come within the jurisdiction of the enacting body but intrude on the jurisdiction of the other level of government because of the constitutional overlap in the division of powers. So it falls under both a head of powers for provincial and a head of powers for federal. Similarly, the incidental effects rule applies where the main thrust of the law comes within the jurisdiction of its enacting body, but the law has subsidiary effects that cannot come within the jurisdiction of that body. In General Motors, Judge Dixon proposed a qualification on the rational function test. He said the necessity test should apply to a serious intrusions on the powers of the other branch of government, while the rational functional test should apply to lesser intrusions. The required degree of integration increases in proportion to the seriousness of the encroachment. Where the impugned legislation encroaches only slightly on the jurisdiction of the other level of government, a rational functional connection is required. As the degree of intrusion grows more serious, the required degree of integration tends towards a test of necessity. A particularly serious encroachment will attract a standard of strict necessity. See Reference Re Goods and Service Taxes in 1992. So that is a great case for the ancillary power doctrine, and it covers a lot of the General Motors case. So very useful. And then finally looking at paramountcy, short and sweet, the Rothmans, Bentzes, and Hedges Inc. versus Saskatchewan 2005 case. So, Rothmans, that company sought a declaration that Section 6 of the Saskatchewan Tobacco Control Act is, by virtue of the paramountcy doctrine, inoperative in light of Section 30 of the Federal Tobacco Act. Section 30, the federal one, allows retailers to display tobacco and tobacco product-related brand elements and post signs indicating their availability and price. Well, Section 6 of the Provincial Act bans all advertising, display, and promotion of tobacco or tobacco-related products in any premises in which persons under 18 years of age are permitted. So the Court of Queen's Bench dismissed the company's application. The Court of Appeal set aside that decision and declared Section 6 inoperative on the basis of a practical inconsistency between the two provisions. So the issue here is whether the provincial legislation from Saskatchewan is inoperative pursuant to the doctrine of federal legislative paramountcy. And the rule here was pretty clear. The doctrine of federal legislative paramountcy dictates that where there is an inconsistency between validly enacted but overlapping provincial and federal legislation, the provincial legislation is inoperative to the extent of the inconsistency. This is from Multiple Access Limited. Another little rule here: provincial legislation that displaces or frustrates Parliament's legislative purpose is also inconsistent for the purposes of this doctrine. This is from Bank of Montreal versus Hall. So a little bit of analysis here, nice and simple. There's no inconsistency, the court said, between Section 6 of the Provincial Act and Section 30 of the Tobacco Act. the Federal Act. First, a retailer can easily comply with both provisions in one of two ways: by admitting no one under 18 of age onto the premises, or by not displaying tobacco or tobacco-related products. The provincial legislation simply prohibits what Parliament has opted not to prohibit in its own legislation. Second, the Provincial Act does not frustrate the legislative purpose underlying the Federal Act. Both the general purpose of the Federal Act, which is to address a national public health problem, and the specific purpose of the Federal Act, the other one was provincial, to circumscribe the Tobacco Act's general prohibition on the promotion of tobacco products, remain fulfilled. So both of their purposes remain fulfilled. In demarcating through Section 30 of the scope of the federal legislation's general prohibition on the promotion of tobacco products, Parliament did not grant retailers a positive entitlement to display such products. So, clear enough, there's no inconsistency here. There's no reason to find paramountcy. And so the appeal should be allowed. The provincial legislation is not inoperative by virtue of the paramountcy doctrine. Both of these can exist at the same time, so paramountcy didn't apply here. Pretty simple, and that concludes Part 7 of the NCA exam study guide. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.